and they shall hold an election within 3 months or such longer period as the National Assembly shall by resolution supported by not less than 2/3 of the votes of all the elected members of the Assembly determine, and shall resign after the President takes the oath of office following the election. Full, final and complete settlement of these issues by a court of competent jurisdiction will place beyond doubt any question which may exist and serve to give guidance to the Speaker and to the National Assembly for the future.
If the proceeding was unlawful, then the whole no confidence motion goes, and not just the vote in order to make it 32-32. These submissions are totally inconsistent. In my view, it is not the National Assembly as a body that acted unconstitutionally, but the second respondent who did when he sat as an MP, who would not have been qualified due to his dual citizenship. No doubt this is why the contrary was argued for the applicant and the Attorney General that a no-confidence motion proceeding was lawful and valid, but not the second respondent's vote.
It's just another day in the life of the courts, and the ruling of the Chief Justice is stage one. We had said that they needed to have 34 votes and not 33. And why is that? It's because you require an absolute majority, what we call an absolute majority.
Justice itself found that Article 106, 6 of the Constitution deals with or provides for an absolute majority. So there is a distinction between an absolute majority and a simple majority. The formula given for the calculation of the votes of all elected members of the National Assembly, because Article 106 says that it shall be the majority of the votes of all elected members of the Assembly. That calculation given by Dr. Lexis was that one has to first find half of the number and then add 1 to it. In all of the cases in the National Assembly of the members, in all cases in the National Assembly, the members are 65. Applying that formula, a fraction comes into being. A fraction is always rounded up and it is not left down. In its view, Article 106 calls for an absolute majority as opposed to a simple majority. And in calculating that absolute majority, one has to round up to the next whole number, since there cannot be half of a person. And since an absolute majority means more than a simple majority, one must be added to that figure. If not, there will be no difference in between the two terms.
And just as happened in Cedric Richardson, where we went on appeal to the Court of Appeal, and then from the Court of Appeal to the CCJ where we won it, and stopped Jagdeo from saying that he could have a third term, we're going all the way again. All right?
So whilst we have won on all the issues of law, as you would have heard, we have lost on maths. And I never thought this would be a case of maths. I thought this was a case of law. But you heard the judges, they rejected every single submission made by the appellant, Attorney General, and Mr. Reid, the farmer, but upheld that singular argument that 33 is not a majority of 65. You will note the judges saying repeatedly that all the council accepted that 106 of the Constitution, Article 106, required an absolute majority. I never accepted that. I always said that they did not use the term or the prefix absolute in front of the word majority. and that the framers of the Constitution did so deliberately. It was always an accepted fact by all sides that if the case is, that the case will go to the Caribbean Court of Justice, and it will go there because this is an important matter. Unfortunately, one issue, just a singular issue, has to be determined now. So this is a case that can be heard within a matter of days.
Now, it is one thing for the court to be put in the position to assess a piece of legislation passed by Parliament and to determine whether that piece of legislation, an anti-defection clause, violates the Constitution, and then to make a judgment applying the normal proportionality test that whereas there may be prima facie a violation, it serves a legitimate purpose, etc., and it is not disproportionate. You make that analysis and you come to the conclusion that there is no violation of the Constitution. That is where Parliament has expressly stated what its intention is, exercising its constitutional authority to amend the Constitution. What my learned friends are asking you to do is to legislate that exception to the constitutional rights by way of an implied limitation on those rights, where that intention, the intention to limit freedom of constitution of conscience, is simply not to be seen in 156.3 at all. With all due respect, that is asking this court to rewrite the Constitution, not just simply to say that there's an implied limitation on the right to vote, but there's an implied limitation on the right to vote, provided that you don't have a coalition government, in which case the implied limitation does not apply to the coalition partners. So
It's clear authority for recognizing the concepts of simple and absolute majority in the Constitution of Guyana, although the terms absolute majority and simple majority do not expressly appear in it. A major contention of all the parties, all the appellants, that the Constitution doesn't have absolute majority and simple majority. Your Honor, at page 11, quickly, if you permit me, at paragraph 32, in referring to Governor General versus Mamaloney, the court says this case is instructive in that section 144.1 of the Constitution of the Solomon Islands provided a formula for determining an absolute majority. And it says this, as, and I quote, unless the context otherwise requires, absolute majority means at least 1/2 of all the members plus one. And remember, Your Honor, our contention in our appeal against the first instance decision of the Learned Chief Justice was that even though the Learned Chief Justice acknowledged it was an absolute majority situation, the Learned Chief Justice did not apply the 1/2 plus 1. The Learned Chief Justice did not divide 65 by 2 and did not round up. And so that's where the Learned Chief Justice fell into error.
So there are really two questions. One is, what is an absolute majority of 65?
Yes, please.
Whether, and secondly, whether in order to achieve the absolute majority, you need to resort to the formula which apparently was resorted to in the Solomon Islands of dividing by 2 and then adding 1, or whether you simply look at the picture as it is and see in an uneven number where the majority lies.
Not have to go back to any process involving the returning officer, but it will be proceed at the level of the Elections Commission, and next week have the swearing in of His Excellency the President.
Anything specific to what happened yesterday that you may want to highlight that bears strength on the ruling?
I believe the most important thing that made clear yesterday as a result of the arguments is that there's no verification process, as the PPP and the leader of the opposition has been content. The returning officer is not required to accept the statement of polls of the PPP or to engage in any back control with them, but to use his
This is a very, very dark day for everything. It has been reported that the Madam Chair has been lying on the ground. One of the elections officers stormed out of the room in a haste, disappeared, and right now, Madam Chair, we are unaware of her status in the room. They are not permitting a doctor to go and see her. Our belief is that, well, at this point we really don't know. We're hopeful that nothing wrong happened to her, that she is maybe just resting. That is our hope, but it is yet to be ascertained as to her status in that room. That the police does not want anyone to go in, inclusive of a doctor, to go and check on her health. The Carter Center is on scene. They're trying to ascertain also with, we also have a number of international observers here trying to ascertain what is going on the ground here. We are hopeful that there is nothing that would be wrong with Madam Chair's health. I mean, initially when the door was open, people were yelling some really, really harsh things about murder and murder and murder. When they got into the room, there was a lot of activity and a lot of screaming, a lot of people crying. But we are hopeful that nothing wrong has happened or nothing bad has happened, that they would permit the doctor into the room to look at the Madam Chair and ascertain her well-being. I think it is very, very important. All of these things pose a serious threat and a serious risk as to what transpired today. And there is no doubt, absolutely no doubt, that this is a very...
Yes. I think you should stop.
Yes, so I
You're
will stop.
giving an avenue to
Yes.
exit.
Yes.
I suggest that
Yes,
you
yes.
take that.
So I just pass it on to see what activities of what you're doing and just attend. And I thank you very much. No, I won't do that. I just take it away. No, I'm just quoting. No, I know. I just want to say to anybody I heard. I should have said this in my ears.
No, but it comes across as intimidation, that you're trying to intimidate the observers when you speak about taking away accreditation.
All right, so I'm just happy that you're here and you're on someplace. Let's live in good spirits. I'm happy to see you. So I'm seeing you for the first time. And just keep on doing with your work. So the last word you're hearing from me is to continue doing your good job.
No, but then it doesn't take away from the fact that you made a threat that you were told to take away accreditation.
No, I'm telling you.
Madam, you did. I
are you listening to me?
But I'm
saying, I told you I wasn't in agreement with that. So please listen to me. I said I wasn't in agreement with it. And just give me an honest opinion. Please listen to me. I said I wasn't in agreement of that.
But then,
I was not in agreement.
Why was that proper?
But maybe I should take it back. Maybe I should take it back.
And I speak.
I should take it back.
Hear me. I speak on behalf of the Commonwealth, the largest concentration of people in the world.
Yes.
And I am not going to have, not leave the Commonwealth disrespected by a threat to take away the benefitation of the Commonwealth. I just speak to the Commonwealth. I'm going for it. I'm going to speak to the Commonwealth Secretary General shortly. She's willing to speak to me. And I have a duty to her to report accurately. And if you cannot know avoid speaking accurately.
Absolutely. I agree.
So that if you want this, because I would just say, no.
Hello.
Then you take it away, but give it back. Because good people have never done this to me yet. And I will not take it.
All right, thank you. I'm coming out. Thank you.
Certain that is the correct thing. You do not invade GECOM. It's like a cricket match. The umpire will have to say, well, you're out. And they have gone in to say all manner of things there. So I just came to make an on-the-spot check. I'm glad, yeah, glad. And I've heard a couple of things. I have heard all kind of, I'm being booed by the PPPX. I just want to go and report back. Are you walking in? No, I've already gone in there.
Mr. Ramjitan, shouldn't the police commissioner be making this check instead of you?
No, well, I want to see, I am involved. Every one of the PPP are hierarchies in there. I can't come in here. Please, it's all right. Quickly, Mr. Ramjitan, do you support full verification of Region 4?
There you had it, the Prime Ministerial candidate.
Good afternoon. Attention, please. This is the Court of the Honorable Madam Chief Justice Roxanne George presiding. All proceedings in this court are being recorded on an electronic recording device. All persons speaking are required to speak directly in front of a microphone and to speak one at a time. The court registrar will remind anyone who is not being recorded properly to speak more clearly or closer to the microphone. The attorneys are required to identify themselves and the parties they represent. There must be silence in the room, and everyone is asked to be as quiet as possible when leaving the courtroom. There will be absolutely no use of any cell phone or any other gadgets in this courtroom during these proceedings. Anyone caught using such devices, it will be confiscated or you will be asked to leave the courtroom. Thank you.
Miller.
May it please Your Honor, Mohabir Anil Nandlal and team for the applicant, Senior Counsel Mr. Mendez is not with us this morning. Thank you.
May it please Your Honor, Neil Boston with Mr. Robinson for the respondents.
Before I actually begin the judgment, just want to apologize for the late start, but it's a lot of material to try to fit in. And I must indicate that whilst the decision is complete, for the most part, the insertion of all the legal authorities has not been totally finalized. But I'll mention them. But I want to indicate also, as I did when I gave the decision in the no confidence motion case, that this court is aware that the decision being given today is of national importance and that it has thus evoked widespread interest and awareness. I understand that whatever rulings are made today are likely to excite emotions of different kinds from the parties involved, as well as the wider audience and community. But I must specifically caution that as the decision is being read, there be no audible reactions, not only because this would interfere with the official recording of the decision, but also I don't want any untoward messages to be sent. This is the decision of the court. National and regional elections were held on March 2nd, 2020 in Guyana. Guyana is divided into 10 electoral districts which correspond to the 10 geographical regions. From all reports, the voting process in all 10 regions went relatively smoothly. Unfortunately, this proved to be the calm before the storm. This is a storm that needs to be calmed as pursuant to Section 99 of the Representation of the People Act, Chapter 103. The third respondent, the Guyana Elections Commission, or GECOM, has 15 days from the date of the elections to declare the results. According to the application, after the close of poll, the returning officers of 9 of the districts, in keeping with the provisions of Chapter 103, announced the total number of votes cast and the allocation of votes to the various political parties that contested the elections both nationally and regionally. However, the announcement of the results for District 4, the largest district for the elections, by the first respondent returning officer was delayed and seemingly mired in confusion. This application contends that Section 84 of Chapter 103 was not complied with by the first respondent returning officer and seeks his compliance, and by extension the compliance of the second respondent, the Chief Elections Officer, and GECOM with this provision. I will refer to the contentions in more detail shortly. Suffice it to say at this point, this is the narrow issue that has to be determined in this case. The applicant is a citizen of Guyana who is a registered elector and who deposed that he voted at the March 2nd, 2020 elections. Ms. Sonia Parag, attorney at law, is a candidate for the People's Progressive Party, Civic, PPPC, in the said elections. They both swore to the initial affidavits in support of the application. Supplementary affidavits by Ms. Parag and additional affidavits sworn by others were filed in support of this application. I will refer to their contents later. The applicant outlined statutory procedures for ascertaining the results of the elections in a district after the close of poll. These are provided for firstly in Section 83 of Chapter 103. In brief, the ballots are counted and the results are recorded on the statements of poll, each for the national and regional elections. Ballots for the respective lists of candidates, as well as spoiled, tendered, rejected, and unused ballots, are placed in respective envelopes and packets, which are sealed and, where required, marked. Thereafter, copies of the statements of poll are prepared by the presiding officers for the polling places,
for distribution to the returning officer for the district, assistant presiding officer, such as the duly appointed candidates or polling agents as are present, and the CEO. Importantly, Section 83(9) capital A provides that a copy of the statement of poll is posted up in a conspicuous place outside each polling place as conclusive evidence of the result of the elections for that polling place unless there is a recount of the votes. Section 83(10) provides that the presiding officer shall place the envelopes with the counted and rejected ballots in the ballot boxes which shall be sealed. The ballot boxes, packets containing balloting documentation, and the statements of poll are conveyed to the returning officer of the district in the company of polling agents or duly appointed candidates of the political parties who are desirous of accompanying them where they can be accommodated in the transportation provided. On the completion of the process pursuant to Section 83, Section 84, Chapter 103 provides for what happens after the ballot boxes and the envelopes, packets, and statements of poll are received by the returning officer. Section 84(1) outlines what occurs when the ballot boxes, envelopes, and packets and statements of poll arrive at the offices of each returning officer. It states, I quote, "As soon as practicable after the receipt of all the ballot boxes and the envelopes and packets delivered to him in pursuance of Section 83(10), the returning officer shall, in the presence of such of the persons entitled under Section 86(1) to be present as attend, ascertain the total votes cast in favor of each list in the district by adding up the votes recorded in favor of the list in accordance with the statements of poll, and thereupon publicly declare the votes recorded for each list of candidates." Section 86(1) states that the persons who are entitled to be present are the returning officer, election officers appointed by the returning officer to assist him in the counting, members of GECOM, duly appointed candidates, counting agents, and others with good reason to be present. In the context of these elections, the latter group would include local, diplomatic, and foreign or international observers. Election officer, as defined in Section 2 of Chapter 103, means the CEO, deputy CEO, a returning officer, a deputy returning officer, an election clerk, a presiding officer, an assisting presiding officer, and a poll clerk. By Section 84(1) capital AA, where an election officer for a polling district discovers a material error on a statement of poll, the presiding officer is to be informed, and if the statement of poll has not been sent to the returning officer, then it is to be corrected with the necessary person signing it. The corrected statement of poll is then to be sent to the returning officer. Then by Section 84, subsection 1, capital A, subsection B, if the mistake is found after a statement of poll has been sent to the returning officer, the presiding officer and the person or persons who signed the statement of poll are to be called for the correction to be made and signed off by the necessary persons. The presiding officer is then required to post the corrected statement of poll next to the original incorrect statement of poll at the polling place. For the avoidance of doubt, the subsection goes on to state that the returning officer is to use the corrected statement of poll to make the declaration of the votes in favor of the lists of contesting parties pursuant to Section 84(1). At the completion of this exercise, the returning officer is to communicate the final count for the district to the CEO. The applicant's claims. In simple terms, the major complaint of the applicant is that the first respondent, who is the returning officer for District 4, has not complied with Section 84 in that he has not completed the addition of all the statements of poll in the presence of persons entitled to be there. It is further claimed that despite these circumstances, he made an attempt at a declaration or made a purported declaration of the total votes cast in favor of each list in the district. That is, he attempted to declare the results of the elections for District 4. From the evidence deposed to by the first respondent returning officer, it is now accepted by all parties that the declaration was made. I would add that from the evidence, the declaration was made despite what clearly was a protest that was unfolding in the GECOM building. So it can be concluded that there was a public declaration of the results, such as to satisfy the requirements of Section 84(1) in this regard. Therefore, it is the circumstances which led to the declaration being made that are to be determined, and whether such circumstances affect the validity of the declaration. As a result, the applicant applied for a number of orders. I won't give them out in detail, they're rather lengthy, but he sought a declaration that the purported declaration of the elections or votes for district number 4 is in breach of the provisions of Chapter 103 and is therefore unconstitutional, unlawful, illegal, improper, null, void, and of no effect. A declaration that GECOM is the only body constitutionally and statutorily authorized to declare the results of the general election. A declaration that the Guyana Elections Commission cannot legally, lawfully, or constitutionally declare the results of the general and regional elections unless the returning officer and/or a deputy returning officer for District 4 or the chief elections officer complies and ensures the compliance with the provisions contained in and letter and spirit of Section 84. He also seeks an order vacating, revoking, setting aside, and/or declaring invalid the purported declaration of the elections returns of votes made by the returning officer for District 4 in respect of the votes cast in the said district for the general and regional elections of March 2nd, 2020. He also sought injunctions. The injunctions were originally sought and granted pursuant to an oral application made before Justice Navindra Singh on March 5th, 2020. These injunctions restrained the returning officer, the chief elections officer, and GECOM from declaring the votes for District 4 without compliance with Section 84, and restrained GECOM from declaring the total number of valid votes for each political party until the returning officer and/or chief elections officer complies with and ensures compliance with the provision, letter, and spirit of Section 84 of Chapter 103. A mandatory injunction was also granted compelling the returning officer, the CEO, and GECOM to comply with the letter and spirit of Section 84 of Chapter 103 and forthwith declare the votes for the political parties for the district. The language of the injunctions was such that they could be interpreted to be final in nature. Mr. Mendez, recognizing that they had been granted ex parte on an oral application, suggested that the court order that they continue until the hearing and determination of this application. Mr. Boston objected, and his submissions in the substantive application revealed why. Mr. Boston contended that these injunctions, being final or permanent in nature, could not be revisited by this court. He contended that as regards these orders, the case was res judicata. He eventually abandoned this submission as to maintain it would have made the hearing of this application an exercise in futility, and the respondents would have simply had to abide by the injunctions. Therefore, for the purposes of this application, the injunctions granted on March 5, 2020 are deemed to be interim pending the determination of this application. At the hearing of the injunctions application, the applicant gave an undertaking to file a substantive fixed date application in support of the application for the said injunctions. The fixed date application was filed on March 6, 2020 and fixed for hearing on March 7, 2020 due to the urgency of the circumstances. Mr. Boston, Senior Counsel, appearing for the respondents, acknowledged service of the fixed date application on behalf of all three respondents. He raised the point in limine, contending that this court has no jurisdiction to grant the applications and orders sought, and that the injunctions were improperly granted, as the issues raised by the applicant belong to a class of questions covered by Article 163(1) of the Constitution of Guyana. Article 163(1) provides for the determination of questions as to membership and elections, and by virtue of Article 163(4) and the National Assembly Validity of Elections Act, Chapter 104, for the filing of elections petitions. It was submitted that only the special jurisdiction of the court could be invoked, so that any challenge to the elections must be presented by an elections petition. It was further submitted that the court has no jurisdiction to grant injunctions by way of equitable relief, so as to restrain the conduct of elections or the conduct of elections in a particular way. Mr. Mendez, Senior Counsel, countered that the issues raised in this application are amenable to judicial review, since they do not fall within the class of questions contemplated by Article 163(1)(bi) or the National Assembly Validity of Elections Act, Chapter 104.
This is so because the applicant is not challenging the results of the elections as they are not known, excuse me, nor does he challenge the elections themselves. The application seeks to have the returning officer comply with Section 84 and facilitate the elections process in accordance with the law, irrespective of what the result might be. In a decision given on March the 8th, 2020, I ruled the court has jurisdiction to hear this application and that the issues raised need not be left for a challenge by way of elections petition. I directed that the respondents serve and file their affidavits in defense by 10:30 a.m. on March 10, 2020, and that the applicant file a reply if necessary by 1:30 p.m. on the said March 10, 2020. The parties complied. Evidence and submissions in support of the application. I turn now to the evidence in support of the application. The applicant, supported by Ms. Parath, states that there was a tabulation and verification process for 9 of the 10 election districts. It was deposed that in these districts, the tabulation and verification process were concluded in the presence of representatives of all the contesting political parties and the international, diplomatic, and local observers, and the results were declared and announced without objection, protest, or challenge from any of these stakeholders. However, as regards District 4, there has not been a completed verification of the votes cast. The applicant contends that the verification process commenced in the presence of representatives and candidates of the contesting political parties, international and local observers, and officers of GECOM. He and Ms. Parath referred to the verification and reconciliation process being disrupted and delayed on several occasions because GECOM and its officers, servants, and agents have refused to conduct the process in an open, transparent, fair, and efficient manner and in compliance with the provisions of the Representation of People Act. In this regard, it was stated that these persons have continued to be willing to conduct the verification and reconciliation process, but that this has been refused by GECOM and its officers, servants, and agents. It was also stated that officers of GECOM had sought to verify information from a spreadsheet, but major discrepancies were disclosed as against the statements of poll in the possession of the contesting political parties. This resulted in objections and protests, and the process was halted so that statements of poll could be utilized for the verification and reconciliation process to be conducted. So the factual matrix relied on in the main is that there were 879 polling stations for District 4 with corresponding statements of poll. 421 statements of poll have been dealt with by adding the votes cast for the various party lists, with there being minor discrepancies which were resolved pursuant to Section 84(1)(a). The problem arose in relation to the 458 polling stations as the process for tabulating the statements of poll was suspended, so that no addition of these remaining statements of poll was conducted in the presence of persons who are entitled to be there pursuant to Section 84(1). Despite this, on March 5, 2020, a declaration of the results for District 4 was made by the first respondent pursuant to Section 84(1). It is contended that to date there has been no lawful or proper declaration of the votes for District 4 in compliance with the provisions of Chapter 103. It was vaguely posited that subsequent to the service of the injunctive orders, there was a purported declaration of the results for District 4 by the returning officer. It was conceded by Mr. Mendez that the injunctions order was not served on the returning officer until the time that he had made the declaration. A further supplementary affidavit was filed by Ms. Parath alleging that she has records of the tally sheets and votes cast in favor of the PPPC. Indeed, she and the applicant had stated in their initial affidavits that they could produce statements of poll for the perusal of this court. Additional affidavits in support of the application were filed by Mr. Zulfikar Mustafa, election agent for the PPPC, and Mr. Charles Ramson, attorney at law, candidate for the PPPC, detailing that the latter had been appointed counting agent. It was also deposed that when he applied for a general final count on March 6, 2020, this was refused on the ground that there were no records at GECOM that he had been appointed as the said counting agent. I concluded in the ruling on the preliminary point that these additional issues, as just outlined, are not for an application such as this. I reconfirm my initial view that these matters would be better canvassed in an elections petition. I am not concerned with the votes cast for any of the parties. As I said above, the issue to be determined in this application is a narrow one, whether there has been compliance with Section 84(1) of Chapter 103. Thus, out of an abundance of caution, I again do not rely on any of this evidence in coming to my decision in this application. Mr. Mendes placed emphasis on the factual circumstances, going through in particular the affidavits by and for the respondents, which I will detail shortly. He referred to the affidavit of the returning officer for District 4 being based on hearsay evidence. He noted that the affidavits for the respondents are contradictory as regards what occurred in relation to the completion of the addition of the votes recorded on the statements of poll after midday of March 4, 2020. He contended that the issue to be determined is whether the failure to comply with Section 84 can properly lead to a declaration by the returning officer. It was submitted that Section 84 is mandatory and that in the circumstances, Parliament would have intended that if the provision was not followed, then any act in this regard would be invalid. It was further advanced that there would be no prejudice to anyone for the returning officer to conduct the process in the presence of persons entitled to be there. Therefore, there could be no prejudice if such an order is granted, for this would ensure that the process is carried out pursuant to the law to ensure public confidence. On the contrary, he posited that the failure to require compliance with Section 84(1) would lead to distrust and a lack of trust in the results that have been declared. He concluded by emphasizing that the process must be transparent. In answer to my inquiry, Mr. Mendes stated that the fact that Mr. Ramsey made a request for a general count pursuant to Section 84(2) was not evidence that there was an acceptance of the validity of the declaration by the returning officer. It was merely done out of an abundance of caution in case it was that the declaration was deemed valid. As regards the reference to what was meant by verification and reconciliation of the statements of poll, Mr. Mendes said that this meant the addition of the statements of poll, and that as the returning officer produces the original statements of poll, the representatives of the political parties would seek to reconcile the information presented with their statements of poll. In this regard, there can be reconciliation. Hence, the reason for the public conduct of the process in the presence of such representatives and other persons. However, he concluded that it would be for the returning officer to resolve any dispute and decide whether to accept what was being put forward. Evidence and submissions in support of the respondents. Affidavits in defense were deposed to and filed on behalf of Mr. Clement Mingo, the first respondent returning officer for District 4, Ms. Roxanne Myers, Deputy CEO, Mr. Aubrey Norton, County Agent for Partnership for National Unity Alliance for Change, Mr. John Adams, Deputy Campaign Manager and Assistant Election Agent for APNU AFC for District 3, Ms. Nicola Trotman, Co-Manager for APNU AFC, and Mr. James Bond, Attorney at Law. The evidence produced by Ms. Myers, Ms. Trotman, and Mr. Bond confirms the confusion that ensued as regards the tabulation and declaration of the votes for District 4. In fact, the evidence in these affidavits, which was not denied by Ms. Bragg in her affidavit in reply, suggests there was mayhem at the GECOM building in which the returning officer's office was located. Given the evidence of Ms. Myers, who produced a report on the tabulation methods for all districts, and Mr. Norton and Mr. Adams, who spoke to the process in District 3, It appears that there is no standard methodology for all districts as regards the addition of the votes disclosed on the statements of poll. Hence the contentions as regards how the votes were to be added for District 4 and the input of the agents of political parties. However, it is noted that while there appears to have been an issue regarding the accuracy and therefore use of a spreadsheet in District 4, the report exhibited by Ms. Myers indicates that spreadsheets were utilized in the process of the tabulation in 8 of the other districts. While Ms. Myers' report indicates that the spreadsheet was not used in District 3, Mr. Norton and Mr. Adams deposed otherwise. The report discloses that the spreadsheet, either alone or in conjunction with other methods of tabulation, was used. In the main, statements of poll were read and a spreadsheet was created. More importantly, the evidence discloses a major inconsistency as between the affidavits of Ms. Myers and Ms. Trotman on the one hand and the returning officer on the other. Ms. Myers and Ms. Trotman support the applicant's contention that apart from delays, which included one as a result of the returning officer falling ill, there was a suspension of the tabulation of the votes somewhere between 9 p.m. and 10:30 p.m. on March the 4th. Mr. Bond also referred to the suspension of the declaration process, though he is not specific as to when this occurred. In any event, a decision was taken to resume on March 5, 2020 at 9 a.m. Ms. Myers said she left GECOM for home when the decision to suspend the process was made at about 9 p.m. At about 9 a.m. on March 5th, she was at the GECOM building when there was a bomb scare. Subsequently, at about 12 noon, a decision was made to resume the process, with persons entitled to be present to attend, including 2 observers from each of the local and international observer groups. Ms. Trotman stated that on March 5th, she checked GECOM regarding the resumption of tabulation, and on receiving a call, returned to GECOM at about 11:20 a.m. Neither of them nor Mr. Bond specifically deposed to whether or how the tabulation process continued or actually unfolded, but went on to say that the returning officer attempted to declare and then declared the votes for District 4. The returning officer, on the other hand, said that the process commenced in the presence of persons entitled to be present from about 10:30 p.m. on March 2, 2020. The process continued in his presence until about 12 noon on March 4th, when he fell ill and left for the hospital. He left a Miss Michelle Miller, senior clerk, to supervise the process. Thereafter, it is evident that the returning officer was personally unaware of what occurred, as he deposed continuously about what Miss Miller told him. The returning officer first stated that Miss Miller advised him that in his absence, supervised by her, clerks inputted data and completed the input of all data in the computer for District 4 at around 7:30 p.m. on March the 4th. Subsequently, he said that the count had already been completed at 9:10 p.m. on the said March the 4th. Ms. Myers, as Deputy CEO, who said she was at the GECOM building when the decision was taken to suspend the process to the following morning, was clearly unaware of this, as she has said nothing about the count being completed at any time on the night of March the 4th. The returning officer also said that Ms. Miller told him that the data had been inputted from the statements of poll and had thereafter been produced as a spreadsheet. Ms. Parag deposed and Ms. Myers confirms that there was objection to the use of the spreadsheet, though as noted above, Ms. Myers shows that spreadsheets were used in other districts. The CEO directed the discontinuance of the use of the spreadsheets after there was protest in this regard. It appears that sometime on the night of March 4th, the returning officer returned to the GECOM building, or he stated that 1, he was in a position to make a declaration but did not do so due to queries which were addressed, and 2, the process was adjourned to March 5th. At 9:45 on March 5th, Ms. Miller was making preparations for him to make the declaration when a large contingent of persons entered the building and caused a disruption. He nevertheless subsequently made a declaration in the presence of a number of persons, many of whom were shouting loudly. The returning officer said nothing about the resumption of the tabulation of statements of poll on March the 5th, to which Ms. Myers and Ms. Trotman referred. Significantly, no affidavit has been filed by Ms. Miller, who it appears played a crucial role in finalizing the tabulation process. Mr. Mendes submitted that Ms. Miller, whose designation has been given by the returning officer's senior clerk, would not have been a proper person to have been supervising the Section 84(1) process, as she was not an election officer as stipulated by Section 86(1), who the returning officer could have designated to assist him in counting. He cited the Tanzanian case of the Attorney General and Monko 1989. Indeed, it does appear that Ms. Miller would not have been a proper official to undertake the important task of conducting or supervising the conduct of the tabulation of the statements of poll. However, while this is an important issue, there is no need to rely on it in coming to a determination in this case. Mr. Boston submitted that the returning officer can adopt whatever methodology he decides to pursue to arrive at the results. He can sit with the persons entitled to be there and go through the statements of poll, or prepare a spreadsheet from statements of poll, and thereafter declare the votes received by the list of each candidate. In this regard, the returning officer is duty-bound to rely on the statements of poll he has received, and not on what Ms. Parag and other members of political parties say they have. He said that Section 84(1) does not provide for the returning officer to listen and resolve disputes, so that if there is dissatisfaction, then the aggrieved party or persons can apply on Section 84(2). It is contended that although the returning officer has not produced evidence of when the tabulation was finally completed, there is a presumption of regularity that he did so. Mr. Boston submitted that even if he has not complied with Section 84(1), by doing a count in the presence of persons entitled to be there, it does not invalidate what was done, and the declaration made thereafter, as the provisions of Section 84(1) are directory and not mandatory. He relied on the dicta of Chief Justice Bernard in the Hamilton case, 40M of 2001, and other authorities on how the court is to assess mandatory and directory provisions. As such, any compliance in this case would not mean that his declaration should be or would be nullified. Mr. Boston also submitted that in any event, there has been substantial compliance with Section 84(1), that is, substantial compliance in advancing the process towards the declaration of the results for District 4 in a timely manner, so that the declaration cannot be invalidated. He said that one cannot consider the numbers of statements of poll dealt with or still to be dealt with in determining whether there has been substantial compliance. He further stated that the returning officer utilized a spreadsheet to make the declaration. There is no evidence to this effect, and I'm cognizant of the evidence of Ms. Myers and Ms. Trotman that a decision was taken to discontinue the use of the spreadsheet that had been generated unto that time. Finally, it was submitted that the avenue for challenge would have to be by way of a request pursuant to Section 84(2) for a recount. In response, Mr. Mendes submitted that Mr. Boston cannot rely on the presumption of regularity, as the affidavits for the respondents do not support this contention. This is so, he said, because the returning officer detailed what occurred and stated that the adding up was done in his absence and advanced what he had been told as proof. So when he says he was absent and that information was inputted by clerks, then we have to accept this. The returning officer also said the process had been completed at 7:30 p.m. on March the 4th, and that he had decided that he was going to make the declaration. Analysis. The position of the returning officer is a statutory one that requires that he or she perform his or her duties in accordance with the law that governs their powers and duties. In this regard, they are bound to ensure that the process and procedures outlined in Chapter 103 are carried out. If there is default, then it is open to the court to exercise its supervisory powers to direct that there is compliance with the law. As held in Regina and Panel on Takeovers and Mergers, ex parte data fin 1987, where a public duty is imposed on an official or body, whether expressly or by implication, the person or body in exercising those publications would be subject to the court's jurisdiction of review, utilizing its supervisory powers. These sentiments are applicable in this case to the returning officer who, as I have recounted above, has statutory duties pursuant to Section 84 of Chapter 103. Importantly, in today's context, where persons are to exercise statutory duties more so in a public manner, unless there is good reason to conclude otherwise, they are enjoined to do so transparently. The process outlined in Section 84 is meant to engender transparency and accountability to thereby ensure impartiality and fairness. I note that in the Hamilton and GECOM case, Chief Justice Bernard, as she then was, considered that Section 84 was not mandatory as regards the time frame in which the additions of the statements of pool are to take place and as to who should be present at such additions. And here I've quoted at length from Justice Bernard's decision. I agree with Chief Justice Bernard that the time frame for the commencement of the adding of the votes as recorded in the statements of poll is directory, as this is to be done as soon as practicable. Whether utilizing the old nomenclatures of mandatory and directory as contended for by Ms. Boston, or the newer language as contended for by Mr. Mendez, in relation to the purpose and what Parliament intended, the result is the same, as no specific timeline is fixed. Therefore, what would amount to a breach as regards commencing the tabulation after the receipt of the statements of poll would depend on the facts of the case. However, as Chief Justice Bernard noted, the provision still requires the returning officer to act with dispatch. In this regard, if there is evidence of inordinate or undue delay, then even though directory, in my view, such may amount to a breach of the provision. But I only mention this en passant, for this is not the complaint in this case. In my view, there are primarily two explicitly mandatory requirements in Section 84(1). A, that the total votes cast in favor of a list in the district must be done by adding up the votes recorded in favor of the list in accordance with the statements of poll. And B, that thereafter there must be a public declaration of the said votes recorded for each list of candidates. I agree with the dicta of Chief Justice Bernard that the presence of all the persons listed in Section 86(1) is not required at the addition of the statements of poll, and that the returning officer has the discretion to determine who are persons who would have good reason to be present. It is also within his discretion as to which elections officer will assist him. I also agree with Her Honor's conclusion that this aspect of the section is directory. But I would add, especially in this era that calls for greater transparency in the actions of public officials, once any of the persons listed attends, once any of the persons entitled to attends, then the addition must be done in their presence. In the latter limited sense, I would say that this aspect of Section 84(1) is mandatory, that is, non-compliance would warrant scrutiny and can result in the invalidity of the process. This may appear to be a fine distinction, but I feel it has to be made in the interest of the credibility of the process and in order to obviate the continued contentions regarding the tabulation and declaration of election results. Posting of statements of poll at the place of poll is one of these safeguards. The public tabulation of statements of poll is another. The question to be posed, as highlighted in Regina Synergy, which is cited by both counsel, is whether it was the purpose of the legislature that the act done in breach of that provision should be invalid. In this case, I also rely on dicta in our local case of Reason Abdullah, 1975, 23 Western Reports 34, at page 36, the dicta of Chancellor Lucko. While the failure to post the statements of poll at the place of poll may be considered directory, as a failure to do so would not affect the results as recorded, the failure to comply with Section 84(1) has much more serious consequences. In relation to mandatory and directory principles, I also quote from the Smith's Judicial Reviews, 7th edition, paragraphs 5-052, 052, and 5063. With this background, this decision boils down to an assessment of the facts disclosed on the affidavits. My understanding of the provisions outlined, more especially Section 84 of Chapter 103, is that the returning officer, in the presence of the persons listed, is to be, pursuant to Section 86(1), is to add up the votes in favor of the political parties according to the statements of poll that would have been delivered to him or her. On completion, he or she is to publicly declare the votes for each list of candidates, that is, for the political parties. I understand the applicant to be saying that the adding up of the votes based on all the statements of poll was not done in the presence of these persons, as this process had not been completed when the returning officer made the declaration. In my view, and I hold that the facts disclose that a significant part of the addition of the votes from the statements of poll was done in the absence of persons who are entitled to be there, that is, in the absence of election officers, members of GECOM, duly appointed candidates, counting agents, and others with good reason to be present. That is, for example, election observers, and as such, the process would have been flawed, and there has been a breach of Section 84(1). As stated earlier, Mr. Boston submitted that there has been substantial compliance with the subsection, and that the principle of presumption of regularity should be applied. I disagree. The dicta cited by Mr. Boston from the Sonechi case, in my view, supports my finding in this regard. It states, what will constitute substantial performance will depend on the facts of each case, and it will always be necessary to consider whether any prejudice has been caused or injustice done. There cannot be substantial compliance when the tabulation of 458 statements of poll has not been accounted for. The returning officer said nothing about how many statements of poll had been added on to when he fell ill and left. He did not refute the evidence for the applicant in this regard, that 421 statements of poll had been completed, and therefore 458 remained to be completed. In addition, it was incumbent on the returning officer to ensure that the addition was done in the presence of persons entitled to be present. Ms. Pratt's uncontroverted evidence is that such persons were available to attend the process. As I noted above, it is unknown how the process unfolded while Ms. Miller was in charge, as she has not filed an affidavit. None of the persons who deposed the affidavits for the respondent has accounted for what happened with the tabulation process from the time the returning officer left for the hospital around midday on March the 4th and on to his return sometime in the evening of March the 5th, of said March 4th. As I have emphasized, the provisions of Section 84 are designed to ensure transparency in the process towards the declaration and the credibility of the election's results. I have concluded that in the absence of credible evidence about what occurred after the returning officer left for hospital until the time he made the declaration, then the presumption of regularity cannot apply. It cannot be presumed, based on the returning officer's affidavits, that the process was regularly conducted. That is, that there was addition of the statements of poll and in the presence of persons entitled to be there. Thus, I hold that there has been a breach of Section 84(1) in these regards. And even if one were to conclude, as Mr. Boston contends, that Section 84(1) is directory as regards the public tabulation, given my conclusion that there has been substantial non-compliance with the requirements of the provision, the result will be the same. The breaches cannot be condoned. But what is the role of persons who are entitled to be present? It is unclear what the applicant and Ms. Parag mean by verification and or reconciliation process of the statements of pool, as there is no provision for this in Chapter 103. They did not explain what they understood the process to be, though Ms. Mendez, as I alluded to earlier, did say it simply meant the addition process with persons raising their concerns with the information provided as warranted. It does appear to me that there is a misunderstanding as regards operationalizing Section 84.1. Section 84, subsection 1A, A, and B clearly provide for the correction of mistakes in the statements of poll. The section does not outline how a material error or a mistake is to be brought to the attention of the elections officer or returning officer. No doubt this will be done by one of the persons entitled to be present, though I would think that observers would be excluded in this regard. Nevertheless, I do not consider that if one or many of the persons entitled to be present is or are dissatisfied with the returning officer in terms of what is recorded, that this entitles these persons to challenge the figure recorded at that point in time, such as to disrupt the process. I do not conclude that the Act provides for verification or reconciliation in this sense. This is especially in the context of the well-known fact that 10 political parties contested the 2020 elections in District 4. If each were to object, more so in a vociferous and or hostile manner, the tabulation process would definitely be delayed, and indeed, there may be risk that it is not completed. Aggrieved persons would no doubt make their concerns known and take note for further action, whether pursuant to the next provision I will outline or by an elections petition. To permit otherwise would be to invite protests and possibly chaos, as outlined in the affidavits in support of this application and for the respondents. Such would not inure to the overall credibility of the process and would exacerbate the already tense and even volatile situation that exists during the elections period, and more so at the conclusion of the voting exercise. In this regard, one would expect the respectful indication of a party's concern or concerns, and equally a respectful consideration of the said concern or concerns by the returning officer, including the making of corrections or adjustments. However, it is not for the persons to so intervene in or stop the tabulation process and ultimately the declaration of the votes, which declaration must be made public because they are of the view that the returning officer has not addressed their concerns. If it is felt that there should be greater participation in the addition process of statements of poll by persons who are not elections officers invited to assist the returning officer, but who are entitled to be present, then there would have to be an amendment to the law. And I note here the case of Singh and Nehru and others 1958, which was cited in the submissions by the applicant in relation to what can happen at the tabulation process. At the end of the day, the only official documents that the returning officer can consider are the statements of poll that have been transmitted to him by the presiding officers of the various polling stations pursuant to Section 83. Any statements of poll in the possession of agents of political parties or others would not be such. As Mr. Mendes agreed, it would be for the returning officer to decide how he would treat with any objections or challenges raised. Such decision-making is not within the remit of the persons who are entitled to be present. Otherwise, they would be usurping the powers and responsibilities of the returning officer pursuant to Section 84. Further, it would be for the returning officer and or the deputy returning officer to decide whether in the interest of transparency, the addition process should be restarted or continued from where it was left off. It would also be for these functionaries to determine the best method of tabulating the statements of poll. Again, it cannot be for the persons present to indicate how this should be conducted, though one would expect that the returning officer would act reasonably in ensuring a process that allows persons to observe what is being tabulated and how. This is especially so given the varying methods of addition of the votes from the statements of poll as disclosed in Ms. Myers' affidavit. But the transparency of the adding process in the presence of persons entitled to be there, in my view, is to permit them to object firstly within the parameters of Chapter 103. This is provided for in Section 84.2. This is to say, if they are not present to take note of the addition, they would not be in a position to ascertain whether there are discrepancies such as to amount a challenge pursuant to Section 84.2. Therefore, if there is dissatisfaction with the addition and ultimately the declaration, then Section 84.2 provides that, well, I'll paraphrase it here. Section 84.2 provides for either general or limited recount on the request of a counting agent before midday of the following day of the declaration. Subsections 3 and 4 provide for a general and final count or limited count to be requested by counting agents in relation to district results. Where a limited count is requested, the counting agent has to specify the polling places in which the final count is to be conducted. The returning officer has to comply with the request. There are restrictions on what is to be checked in a limited count, and this is provided for in subsection 4. Subsections 5 and 6 provide further details on how the final counts are to be conducted as regards general and limited counts respectively. And ultimately, a challenge can be launched by elections petition after the declaration and gazetting of the elections results. Conclusion and orders. Taking all the above into consideration, I have concluded that there has been substantial non-compliance with Section 84.1 as regards the addition of all the statements of poll for District 4 and as regards whether such was conducted in the presence of persons entitled to be present as attend. The non-compliance is such as to vitiate the declaration of the results of the addition of the statements of poll for this district. I do not consider that the declaration sought that GECOM is the only body constitutionally and statutorily authorized to declare the results of the general election pursuant to Section 96 to be necessary. This is a given fact, and such an order would be odious. However, it is hereby ordered that 1. The declaration made on the 5th of March 2020 by the returning officer for District 4 of the total votes cast for District 4 was unlawful as being in breach of Section 84.1 of the Representation of People's Act, Chapter 103, and is null void and of no effect. The declaration made on March 5, 2020, by the returning officer for District 4 of the votes for District 4 is hereby vacated and set aside. Any act done in pursuance of the said declaration is hereby deemed null and void and of no effect. Subject to my admonition as regards the role of persons entitled to be present and attend, the returning officer and or the deputy returning officer must comply with Section 84.1 in ascertaining the total votes cast in favor of each list and the public declaration of votes so recorded for each list of candidates. And as I mentioned earlier, I think I'll move this paragraph to here. As I mentioned earlier, it would be for the returning officer, the deputy returning officer, to decide whether they will restart or continue the process. It is their decision to make. And I also would repeat here, it would be their decision to decide on what is the best method for tabulating the statements of poll. So I want to emphasize that everybody else who thinks they can have an input and a say, it's not their statutory duty. It is also ordered that the Guyana Elections Commission cannot lawfully declare the results of the elections of March 2, 2020, unless and until the returning officer or deputy returning officer for District 4 complies with and or ensures compliance with the provisions of Section 84.1 of Chapter 103. If an injunction is granted restraining the returning officer of District 4 from in any manner whatsoever declaring the votes recorded for each list of candidates for District 4 before complying with or ensuring the compliance with the process set out in Section 84 of Chapter 103. That injunction is now made final. The injunction granted restraining GECOM from declaring the total number of valid votes cast for each political party until the returning officer or deputy returning officer for District 4 complies with and ensures compliance with Section 84 of Chapter 103 is also hereby made final. The mandatory injunction that refers to the compliance with the letter and spirit of Section 84 is hereby discharged. Because of the urgency of the situation, the following consequential orders are made. The returning officer or deputy returning officer for District 4 are to commence compliance with Section 84(1) of the Representation of People Act, Chapter 103, no later than 11 hours on Thursday, March 12, 2020. That in the interest of transparency, but taking into consideration the need for urgency, the returning officer and the deputy returning officer for District 4 is to decide whether the process of ascertaining the total votes cast in favor of each list in the district by adding up the votes recorded in favor of the list in accordance with the statements of poll should be restarted or continued. It is also ordered that this order is to be served in council for the parties and is to be deemed service on the parties. Before I conclude, as Chief Justice Bernard had to do some 22 years ago in the matter of application by Aubrey Norton, I must stress that this decision does not decide the result of or the validity of the elections for District 4, regionally or nationally. This decision is concerned with the conduct of returning officer in complying with Section 84 of Chapter 103. Further, I must lament that it's particularly saddening that 19 years after the Hamilton case, the words of Chief Justice Bernard as follows still ring true. I quote, "The role of the Elections Commission and its staff is to take such action as appears necessary to ensure impartiality, fairness, and compliance with the provisions of the Constitution and any other acts of Parliament. In the present volatile situation which pervades our country, no effort must be spared to assure everyone that the process was fair and impartial. Lingering doubts that hang like a sword of Damocles over the head of the Commission must be removed. Confidence in the electoral process must be restored. This is essential. This is absolutely essential if we as a nation are to move forward and strive to heal the wounds that divide us. Let fairness pervade all of our actions at all times." End quote. I could not have said it better. I would add that going forward, all must strive to encourage respect for the other. While elections are often fraught with anxiety and sadly even a lot of hostility, it must be remembered that the election staff are human and they must be treated with respect. Leaders of the respective political parties must encourage their supporters to be civil, respectful, and responsible. The integrity of our nation demands that we act responsibly. In this regard, I am compelled to again admonish all to respect the processes and orders of the court. That is the judgment of the court. Can the parties agree on cause?
Your Honor, first of all, permit me to express...
I hear you clearly, Mr.
Permit me, Your Honor, on behalf of all of us, and I'm sure I can embrace my learned senior, Mr. Boston, in extending our deepest gratitude to the court for dealing with this matter with the exceptional alacrity that it has, and most deserving. And Your Honor would have had to assimilate a volume of materials, and you have done so within a time frame that is remarkable. Your Honor, there is an aspect of the order that I wish to get some clarification on. In the course of Your Honor's judgment, Your Honor made reference to the presence of the parties being part of the Section 84 exercise. I think, Your Honor, in your judgment, you alluded to the fact that once the parties present themselves, in the interest of transparency, they should be accommodated. Might I respectfully suggest that that be made an express component of the judgment in the order that Your Honor granted. The orders, I do not recall an accommodation being made for that. Your Honor, I am sure the court appreciates the tension which unfortunately permeates this matter, and I have no doubt we are all hoping that it will dissipate when the exercise resumes. But Your Honor, if the order is expressed in the clearest possible way, it will deeply enhance the process.
I have to hear Mr. Boston.
Yes.
But before just a minute, Mr. Boston. I'm trying to understand how you want it formulated, Mr. Nandalal. I mean, that sounds like letter and spirit, and
no,
it's problematic because then you get into how does a person comply with it, and you say they haven't complied, they say they haven't complied. From all that I've read in the affidavits, it is very clear that the persons who were there and were always there. So I don't see why it has to be in an order.
I just wanted to, when Your Honor is ordering that the process, that Section 28,
Section
84 be complied with, and I know that you have put it in the control and discretion of the returning officer. He controls the process. I guess
that's what the law provides.
The gravamen of your order. But I would just like to say that once the parties' representatives present themselves, they must be accommodated. I think in the ratio of the judgment.
I don't know whether they want to say they must be accommodated, because then we get into a situation accommodated how? Are they to stand? Are they to sit? I'm sorry. That's a recipe for.
No, but Your Honor, the Section 84 itself, if I may, and I hate to do this, Section 84 itself, Your Honor, the express text of the section, as soon as practicable, after receipt of all the ballot boxes and the envelopes and packets delivered to him in pursuance of Section 8310, the returning officer shall, in the presence of such persons entitled under Section 86 to be present, as attend, ascertain the total votes cast by adding up the statement of poll. Now, if one is to go to 86.1 now,
Mr. Nala, I've detailed 86.1 in the judgment.
And 86.1, Your Honor, lists
who can be present.
Duly appointed candidates and counting agents.
Yes.
So all I'm asking that the text of Your Honor's judgment, the orders, consequential orders and substantive orders, reflect that. That's all I'm asking you.
Mr. Nandalal, I'm very sorry. I'm just not understanding how that can be reflected in an order.
I'm not saying it will.
I said I'm not understanding how that can be reflected in an order. Maybe let me hear Mr. Boss. Maybe you can draft something whilst you.
If I get what Your Honor has already, perhaps I can.
But then if I've already, then it's here. Yes, Mr. Boss.
Is that the GECOM should comply with the statute. And that is what they are going to do. I don't know if Mr. Anil Nandalal intends to put 100 people in GECOM. 25 represents agents, 25 represent duly appointed candidates. No. That will lead to the confusion that brought these proceedings. So
that's why I can't give that decision, because I don't even know who people have to present. I'm not going to get involved in that. I asked the question, Mr. Nandala, you have not answered it. I asked you if the parties can agree on the issue of costs.
Well, Your Honor, I haven't had time to engage my learned senior, but cost follows the event. We had to bring lawyers from Trinidad.
That was your choice.
We had to work, Your Honor, under tremendous stress and under very difficult circumstances. I remember the last time Your Honor issued cost against me was $500,000. If I can return the favor to the Elections Commission, I don't mind.
Yes, Mr. Moss.
I don't think this is an issue. This is an issue of national importance, and one should not award costs. This is a landmark decision, and you should, in your discretion, don't award any costs. This has moved. This has enlightened the jurisprudence, and that is why we hear this. Your cause doesn't arise.
I'll return the $500,000 to Mr. Nandalam. You see, the Judicial Review Act has a whole regime on this, and the CPR, and we don't really need, I shouldn't say we don't really need. I prefer it if we didn't have to go down the road of having to have a court hearing.
I know that.
So, you know.
I will accept the court suggestion.
Of the $500,000?
Yes, Your Honor. Your Honor, might I inquire, Your Honor made an offer to me, which
yes.
I respectfully would like to
but let me hear it now.
accept if I can assist the court in inserting or
Mr. Nanda, you'll have to do it right now.
Yes, right now.
Order is, we are running on a clock.
I know, Your
so
Honor. I can
let me hear what you have to say.
All I want, Your Honor, is that, and of course that can be determined how many, but that the representatives of the political party be allowed, as the law provides, that's section 4.
But then I don't have to say that.
Well, I just want to make that clear, because that unfortunately is not expressly stated in Your Honor's order. So you mentioned a lot of other things. So I don't want the argument
But that
to
is
arise.
what that is concrete and that can be done. Compliance to Section 84, which refers to Section 86(1), tells the returning officer who has to be there. I would want to say to you, Mr. Namdal, in response, that then it is incumbent upon you and all other political party leaders to be reasonable. So you can't turn up there with a multitude of people.
I appreciate
that. So then the court doesn't need to say that.
I am glad Your Honor has clarified that.
The court does not need to tell you that. That's why I said it's a question of being responsible.
Your Honor, we should not have been here if we were responsible.
Well,
that's the truth.
The fact of the matter is that there is no need to cast blame. All sides have contributed to the issues that we have had to ventilate. And further, I say not. Marshal, please raise it.
I thank you once again, Your Honor.
tabulation of statements of polls for region number 4. She said the returning officer had breached the law when he did not complete that, which is the process stipulated in Section 84(1) of the Representation of the People's Act. That piece of legislation, of course, requiring that the returning officer tabulates the statements of poll received from the polling stations in his district in the presence of persons who are entitled to be there, including party agents and other persons that he may deem fit to be there. In most cases, the returning officer would allow the presence of the international community, including observers for the elections. So standing by outside of the High Court for reactions from the attorneys in this case, the attorney for the returning officer, Senior Counsel Neil Boston, gave a commitment that the returning officer would comply with the judgment. The judge ruled that the process must recommence on Thursday at 11. Mr. Latterton, could you give a comment on the ruling today?
I think the ruling is pretty clear. The supposed declaration has been set aside. We have to restart the verification process. That's pretty much. So we wait for it to restart.
You prefer restart or continue?
Well, that's for the regional officer to decide whether to restart or whether to continue.
What about who gets to observe the process?
Well, the law says that anybody who is mentioned in Section 84 is allowed. I presume it'll be restricted to numbers, how many of each. Whether it's 2 of each, whether it's 10 of each, the returning officers again going to decide that. Well, we haven't been able to see the statement of polls since Thursday night when everybody was evicted from the building. We'll find out when we get there now what state they're in and what it is. But we can only do what's in front of us. So we now move forward.
Are you concerned about the process of verification or reconciliation, given that considerable mention was made of that?
No, we're worried about where the statement of polls were and who had them and what's happened. So that's where we're going to be looking at next, I guess.
Doesn't your party have representatives who are actually guarding some of these electoral materials?
No, they were all put out of the building. The police came, a TSU squad, armed people, and removed everyone from the building.
I'm talking ultimately here about the votes that have been cast.
Oh, at the ballot boxes? Yeah, I think everybody's been keeping an eye on where they are. So maybe what we should do is go back to the ballot boxes. That's even a longer process than we have now.
But how?
Thank you, sir.
Possibility is straightforward.
So we've been speaking to Mr. Sanjeev Dattadin. He's one of the attorneys for the applicant in this case, Mr. Riaz Holiday. He come to the court to say that the returning officer from region number 4 did not comply with the legislation which requires the tabulation of statements for the region in the presence of parties who are entitled to be there, such as party agents, elections commission, and as other returning officers has the diplomatic respondent in this case, Mr. Neil Boston, as you reported, as you would have heard from the court, the judgment there, Mr. Boston saying that he will comply, his client will comply with the ruling of the Chief Justice. She said that it would be for the returning officer to decide who he would have in the office at the time that the tabulation process continues. As she said, it would be for the returning officer to decide whether he will start afresh or if he will continue the process. You would recall that 421 statements are already checked in the presence of various persons. So we can now speak with Mr. Boston.
Your reaction to the ruling? It was a bit disappointed, but we have achieved something. We are going back to GECOM and we are going to get the process moving. and then another declaration will be made. That's all I wish to see. That's all I wish to see.
There was some specific reference made to verification. Your response to that, how the Chief Justice dealt with that issue?
No, well, there's no such thing as verification. It's a question you calling out from your statement to poll, and then either what they have tally with what you have, and that's it. The verification is used loosely.
Are your clients prepared to go ahead tomorrow at 11 hours as they're ready?
That's an order of the court. That's an order of the court. They don't have a choice. We are not thinking about appeal. We are not thinking about appeal. We are ready to roll the process.
Mr. Boston, the judge had said that all parties should be reasonable in this case. Do you suppose that would include your client?
They have not acted unreasonable. They have not acted unreasonable. They will continue to act reasonable.
I meant about the process at the office for the count of the statements with polls. There will be some amount of reasonableness on the part of your client.
What do you mean by reasonableness? You expect that each party will bring 20?
Not each, perhaps one or two?
Well, that is not in my remit. That's a decision for the returning officer. I have no doubt that they were acting reasonably in the process, and they will continue to act reasonably in the process. What gives rise to the behavior, the disorderly behavior, is the political party mob. That's it. They will continue to act reasonable.
I know you won't cover that.
Thank you.
Justice Bernard, coming after Justice Bernard more than 20 years ago, what makes this one a landmark ruling? What makes this ruling, you did remark in the court that this is a landmark ruling. What makes this one a landmark ruling?
That was in an effort to reduce the cost. That was to gild the lily. So that was to gild the lily so we can get a smaller cost. But you would have seen she looked at me and she winked her eyes and laughed because she knew I was trying to gild the lily.
Thank you, Mr. Boston, do you think the integrity of the statement of poll has been compromised?
No, none, not at all. And it will not be compromised.
Mr. Neil Watson there, Senior Counsel, the attorney for the respondent in this case, the returning officer. Speaking to us there, he had said that his client will comply with the ruling in this case. So again, we're reporting from the High Court here, where the Chief Justice Roxanne George has just ruled that the returning officer for Region Number 4, or the Electoral District Number 4, breached the law when he discontinued the process that he had started for the tabulation of statements of poll for Region Number 4. So at the moment, we will try to go in to hear comments from Mr. Anil Nandlal, one of the attorneys there for the appellant.
We knew that the process was not complied with. We knew what the legislation provides. We knew we were supposed to be present, and this is how the process was conducted. And it was not done in accordance with the law. And we have been doing this year in, year out, elections after elections, and we can't seem to get it right. This action was completely unnecessary. And that's why the Chief Justice had to say that after 19 years of Chief Justice Bernard reprimand, we find ourselves at the same position all over again. People have to understand that there is a democracy at work. And when political parties lose an election, they have to accept the results. In 2015, the PPP were told that they lost the elections and they accepted the results. No one broke up the process, and that is what you have here. Hopefully now, one can only trust the RO will carry out his instructions and his duties and obligation in accordance with law. Let us hope that the statements of poll have not been tampered with. You know, the building has been under surveillance. We're locked out of the building, so I don't know what is happening with the statements of poll. And hopefully the observers and the political parties will have an opportunity to be present at the process. I see some heads of state from CARICOM are here. Hopefully they oversee the process, and we can remove the suspicion that is attached to the process and the system. I want to take this opportunity also to commend the Honorable Chief Justice for working under extremely difficult circumstances and for delivering a judgment at such a fast rate. You know, the amount of work that had to have been done over the past few days, and I think the court acquitted itself well, and it's now for us to ensure that Section 84 and the accompanying sections are complied with both in its letter and spirit.
Are you comfortable with the returning officers starting over the process, or you want them to start from where they stopped?
My personal preference would have been for him to resume where he left off, because a lot of work was done, and that did not evoke any controversy. So I think all parties accepted the number of boxes that were verified so far. I hope that the returning officer resumes rather than starts all over again.
And at the end of the Chief Justice's ruling, you were trying to persuade her into getting to the to get to say what is reasonable.
No, I was simply reminding the Chief Justice read out a number of orders, and they all speak to elements of Section 84 that must be complied with. All I was doing was drawing to Her Honor's attention the fact that political parties have a right to be represented under Section 86, because Section 84 refers you to Section 86, and her order didn't make express mention of that. But fortunately, she said that, of course, that is provided for in the law, and she doesn't need to mention that expressly.
My question is, how many persons do you believe is a reasonable amount to be there to present day?
Well,
yes.
Well, the GECOM, I believe, as a commission, should decide that. It should be, as the Chief Justice said in her judgment, and as Chief Justice Desiree Bernard said in her earlier judgment, the purpose of all these exercises is to ensure that the process is transparent and appears to be transparent and fair to the society and to the electorate. And no effort should be spared to ensure that that transparency is there, to dissipate and remove suspicion and mistrust, which unfortunately cloud the atmosphere surrounding the exercise.
So wearing your political cap now, are you convinced that your party will be victorious after this process is redone?
Once the statements of poll that we have, which we received from the respective presiding officers, are upheld, then we will be winning the election. We have won the elections on those, and those are not. I see people saying that they are PPP statements of poll. I want to debunk that. They are not PPP statements of poll. They are statements of poll generated through GECOM, given to PPP polling agents at the close of poll by the presiding officers at the respective polling stations, who are agents of GECOM. So they're not PPP documents, they are GECOM documents. And I want to make that very clear. No, they are not. You can look at them, Gordon. You can look at them, and you will see there are no alterations and so on.
But the court also says, you into whether or not the current statement of polls at GECOM has been tampered with.
No, I'm not getting into that. I'm not getting into that. I'm saying that I hope that their integrity is intact.
But how do you balance your preference for what you're saying there with the fact that the court also pointed out that ultimately in a point of dispute it will be the split statements of poll that was
No,
passed on from the presiding officer to the returning officer.
I understand fully what the code said. But I wanted to make it clear. I just heard it being used all the time that there are PPP statements of poll. They're not PPP statements of poll. They're all GECOM statements of poll. And therefore, it would be rather miraculous if GECOM statements of poll collides, because they are all GECOM generated documents. All of them have a stamp of GECOM. They all are signed by GECOM officials, subscribing to their authenticity and accuracy. So if they are produced and they conflict, it would be quite a miracle. That's all I'm saying.
But aren't they replicas?
They are. That's what I'm saying. They're replicas. Therefore, they should not be different. They should be on all fours. They are carbon copies of each other. So there should not be any difference.
Thank you very much. So we are still live at the High Court. You've just heard from Mr. Anil Nandlal, one of the attorneys representing the applicant in this case. Mr. Riaz Hollider had moved to the court to have the returning officer for Region Number 4 comply with Section 84(1) of the Representation of the People Act, which stipulates that the tabulation of the statements of poll for Region 4 be done in the presence of persons who are entitled to be there, including party agents and international observers. Well, she said that it would be up to the returning officer to decide whom he wants to be present there. In the other 9 regions, the other persons there were taken to mean the international diplomatic community, local and international observers. The Chief Justice ruling that there must be a restart of that process by 11 tomorrow. That's 11 on Thursday. And that it would be up to the returning officer to decide what happens in his office in compliance with the legislation. She had ruled that the declaration made last Thursday by the returning officer, Claremont Mingo, is null and void, and that the Guyana Elections Commission cannot act upon it. And so that's our broadcast here from the High Court. We will, of course, bring to you news on what's unfolding at the returning office from tomorrow at 11 when this process is due to restart. From the High Court, I'm Neil Marks reporting for the newsroom.